I'm Kelsey Reichman, a journalist covering the Supreme Court. You might know that the Supreme Court started a new term this week, but Monday was a little lackluster, to say the least. However, Tuesday we got into more substance and probably what you recognize more from the Supreme Court. The justices heard arguments in a case known as Childs v. Salazar. And this case concerns Colorado's ban on conversion therapy. This is the treatment that tries to change somebody's gender identity or sexual orientation. And so Colorado is one of 25 states that bans this kind of therapy, but a religious counselor said that she has a First Amendment right to offer this therapy to her clients who request it. So while this case is a big deal and it gets headlines because it involves the First Amendment and transgender rights, and that all makes it look very flashy. But the issue in this case is very, very narrow. So while it's a big deal, there is this small area to which it applies. So this would only apply to minors who would want to receive this therapy, who are seeking out this therapy, and it only applies in the talk therapy space and if it is a licensed counselor. So this doesn't apply to, say, life coaches or a religious counselor. What this counselor says is that Colorado can't regulate this very fine area of her practice because that is covered by the First Amendment. Colorado, along with 25 other states, bans this type of therapy. And Colorado says that this is conduct. They say that while she is speaking and, expressing her viewpoints, this is about her conduct in a medical arena, right? Because counselors, even licensed counselors who want to express views about conversion therapy, that's fine under this law. They can talk to their patients, they can express their own views, but the idea is that in a medical context, in the relationship between an individual client and that medical professional, under Colorado law, they do not recognize conversion therapy as an approved form of therapy. And so, therefore, they have banned it. They said you can't try to change someone's sexual identity or sexual orientation or gender identity because medical expertise says that that is harmful. And to be clear, Colorado was backed by many medical organizations who say that this kind of therapy is really harmful and that they've done studies and that they have not found any efficacy to this therapy and that it could actually harm people instead. The weird thing about this case, though, is that Childs, who is the counselor in this case, she brings her own evidence in the case, and she says, well, I have studies that prove the opposite, prove that, people are seeking this out and they're not getting the care that they need, and that this actually helps children who are struggling with these issues. So there's this kind of weird conversation happening in the case where it's almost, choose your own expertise. Like, whose expertise do the justices believe in this case? Because both sides are putting forward evidence that they say proves their point, which seems a little bit difficult. It can turn into this situation where, who do you really believe? Like, if you're not going to trust those medical organizations, then, what's the difference between a study from somewhere else? And, how do you classify whose study should count and whose shouldn't? And I'm not sure we got any clarity on that. Something that the justices will have to do is figure out how to evaluate these kind of laws. So the lower courts evaluated this law and they upheld it under something called rational basis review, which is the standard of review for laws like this when you're questioning whether they are constitutional. Now, Childs says that this should have been reviewed under strict scrutiny, which is a harsher form of scrutiny. It's more tenuous. You have to prove a lot more. And basically in that scenario, you have to prove that even if this did infringe anyway on a constitutional right, that there was a good reason for it. We're not clear if the Supreme Court is just going to decide, hey, the lower courts got this wrong. You applied the wrong form of scrutiny here. Go back and apply strict scrutiny. They could also, however, just decide you applied the wrong standard lower courts, we will apply a new standard for you. And they could do the strict scrutiny review for themselves. After about an hour and a half of arguments this morning, the Supreme Court did appear likely to think that Colorado's law needed to be reviewed under strict scrutiny. And I think it's fair to say that they seemed likely to strike down Colorado's ban, which would impact all of the bans across the country. And how they do so will be really interesting. There are some legal experts who think that the Supreme Court, if they do apply strict scrutiny in these cases, they could end up kind of watering down strict scrutiny across the board. And that would apply to other constitutional scenarios where laws are being challenged, and that kind of scrutiny is less tenuous. Something to watch in that arena were conversations about what Colorado would have to do to prove that its law should be upheld. And so there were some thoughts that, do they have to provide a study, not only that conversion therapy is harmful, but this specific form of conversion therapy, if you're only looking at minors who would consent to the therapy, and it was only talk therapy, it did not go into any of the other what are called aversion types of conversion therapy. And this is kind of where you hear those horror stories about conversion therapy, about, electric shock therapy and, things of that nature. And so this is specifically in the talk realm. So there were questions from the justices about whether Colorado would have to kind of parse this evidence to see if they could prove that talk therapy was also harmful, I guess, separately. Colorado seems to think that their evidence already proved this because the early forms of conversion therapy only involved talking. And, Colorado stressed that conversion therapy, the idea that you can change basically this, who you are, that attempts to kind of change your gender identity or your sexual orientation. They said, this has never been something that has been successful. And Colorado said that laws like this are really enacted in cases where there is medical consensus, but for some reason the public still wants to access a treatment. And she gave an example of steroids. There's consensus that it's bad to take steroids, right? That's not a good thing. But people still want to do it. Colorado stressed that it's not going out and prosecuting these cases. A case was not brought against Childs, and there's a lot of questions about whether, Colorado would even bring a case or if there are any complaints against her. But this law is in place so that if a patient feels like their doctor has violated it, they can file a complaint, which then goes to the licensing board. And there's a whole process before Colorado would actually prosecute somebody under this law. So it just really goes to that. But this is a very narrow scenario, really. It's kind of a strange case where this is about a law that is only enforced when a complaint is filed, and it only applies in cases where the minor consents to the therapy, and it is only talk therapy. And that's not to downplay the impact of the court's ruling, but it is to kind of contextualize what the court is looking at here and what the Supreme Court's ruling could mean if they were to rule against Colorado in this case. Something interesting that got brought up during arguments is last term the Supreme Court ruled in this very big case known as Skrmetti, and that dealt with Tennessee's ban on gender-affirming care for minors. And this was only hormone therapy, and it only applied if you were using it to affirm your gender identity that was different from your sex at birth. And so the Supreme Court upheld Tennessee's ban on this kind of gender-affirming care. But it does look likely that they are going to prevent Colorado from acting in this way. And while this is a different scenario, there are different constitutional questions being asked between these two cases. Justice Jackson brought it up that there's kind of this, comparison. And I think that is a a comparison that is going to be made in the larger public, while the Supreme Court rules on these very specific details of cases that are broken down into, this is a First Amendment case versus this is equal protection, and they're different in all of these ways. I do think that Jackson touched on an idea, and she does this a lot in her opinions, where she is more speaking to the public than she is speaking to her colleagues on the Supreme Court. She said, why is it in this scenario that these two laws that are really evaluating very similar things, one is okay and one isn't? And I do think that that probably will be how the public digests this ruling and the court's review of these issues. I do think it's interesting that this got brought up during arguments. Usually this is a conversation that kind of happens outside of arguments in, the press coverage of an event, or how people talk about the case with, their friends and peers. But it was interesting to kind of almost see this Jackson kind of break this fourth wall. And she's done this before in her dissents, where she's kind of saying, hey, it does really seem like we're treating these two laws very differently here. Once the Supreme Court hears oral arguments in a case, they spend the next few months writing the opinion, and that will likely be released in June. I wouldn't expect it too much sooner.